Criminal Procedure Code. It is welcome to online class.
Okay, welcome to online class on Criminal Procedure Code. Yesterday we had discussed when a police officer may arrest without warrant. When a police officer may, without an order from a magistrate and without warrant, either from the order from the magistrate and without warrant, can arrest without warrant. May arrest, may word is there, not can will not be proper. So when a police officer may, without order of the magistrate or without warrant, arrest a person. First is when in presence of a police officer, somebody commits a cognizable offense. He can arrest. He may arrest. Second, then you should remember this B. B is very important. What it says? Against whom a reasonable complaint has been made, then credible information has been received, or reasonable suspicion exists. Three circumstances. Against whom a reasonable complaint has been made. Simply a complaint has been made. That is with some reasons. Reasonable complaint has been made. Or a credible information has been received. That means no complaint has been made, but the police officer has received credible information. Or reasonable suspicion exists that the police officer, nobody is complaining. Credible information is not there. But there is a reasonable suspicion of the police officer exists. But that he has committed an offense punishable with imprisonment of less than 7 years or up to 7 years. Up to 7 years. And the police officer is satisfied that the person against whom such a complaint has been made, such result credible information has been received, or reasonable suspicion exists that he has committed that offense. First satisfaction. Then the second satisfaction is that if he will not be arrested, then he will commit similar type of offense or commit similar offense. Commit not similar further offense. If he will not be arrested, he will commit further offense. Second, or to prevent such person from committing any further offense. This is second. For purpose of investigation, his arrest is required. First satisfaction that he has committed the offense, and the second satisfaction that for the purpose of investigation, his arrest is required. Or he is satisfied that to prevent such person from causing disappearance of evidence, that is causing evidence of the offense to disappear, or to tampering, preventing tampering of the evidence with such evidence in any manner. Tampering of the evidence in any manner. That is third. Second, or that police officer is satisfied that to prevent such person from making any inducement, threat or promise to witness, to any person. Witness term is not used to any person who is acquainted with the facts and circumstances of the case, and he will not disclose such facts and circumstances of the case either before the police or the magistrate or the court, so that dissuade such person making by inducement, threat or promise. Inducement, threat or promise, again inducing, that is instigating somebody, persuading somebody not to say. That is inducement, threat. Suppose you will disclose, some threat is given to him that some offense will be committed or that he will be faced with some injury. Some threat is there. Or promise, some promise that we show that promise either paying money or anything, promise. If you will not be arrested, there is such inducement, threat or promise cannot be prevented, so that any person who is acquainted with the facts and circumstances of the case will be dissuaded to disclose such facts and circumstances of the case either before the police or before the court. Then again, there is, or the police officer is satisfied. Unless such person is arrested, his presence in the court, but cannot be procured, can be, that means whenever required cannot be ensured. His presence in the court, whenever required, cannot be ensured. And again, that this, for recording this satisfaction, that arrest is required, the police officer must record the regime. Why such things are there? Why? What are the reasons? What are the cause for which the police officer is satisfied that any of the condition is there for his arrest? If he will not arrest, again a duty is also there. If the police officer will not arrest for the commission of a cognizable offence, or commission of an offence against whom a reasonable complaint has been made, but reasonable complaint, credible information has been received, or reasonable suspicion exists that he has committed an offence punishable with less than 7 years or up to 7 years, and his arrest is not required. For that, the reason must be also be mentioned. But for these guidelines, these parameters are to be followed for the police to arrest a person for when there is allegation that he has committed an offence punishable with less than 7 years imprisonment or up to 7 years. But when the allegation is that he has committed an offence which is punishable exceeding 7 years or death, in such case, such satisfaction is not required, but only one satisfaction, that he has committed that offence. That in BA, you will find other two things: reasonable complaint has been made or reasonable suspicion exists is not required. Only where against whom a credible information has been received that he has committed cognizable offence, punishable with imprisonment, which may extend to more than 7 years, or with or without fine, or with death sentence, and the police officer resumed to believe, your satisfaction is not there, has resumed to believe that on the basis of such credible information that such person has committed the offence which is punishable with imprisonment exceeding 7 years, with fine or without fine, or with death. Now, the other conditions are there, in other cases. That means police officer can arrest without, that means who has been proclaimed as an offender either under the Criminal Procedure Code or by order of the state government. Proclaimed offender. How a person will be declared as proclaimed offender. That is provided in section 83 of the Criminal Procedure. What it says? Proclaimed offender. First, there will be a proclamation. Proclamation requiring that person to appear before the court within a particular time or on a particular date. If it doesn't appear, then there will be proclamation, and proclamation has been issued against an accused who is involved for committing there is allegation for committing offence, heinous offences such as murder, etc. In such case, again there will be proclamation declaring him that he is a proclaimed offender. Two proclamations. First, proclamation for his appearance, his surrender. Again, in use of a second proclamation in the same manner. When we will discuss the provisions of section 82 and 83, we will discuss in detail how there will be proclamation and how a person will be proclaimed. In all cases, an accused cannot be declared as proclaimed offender. Only in certain heinous offences that accused can be declared as proclaimed offender. So, if an accused has been declared as a proclaimed offender, either by the court or by the state government, then in such case, the police officer may arrest that person without warrant. Then, in whose possession, this is previous, in whose possession Anything is found which may reasonably suspected to be stolen property. That means in whose possession any property is found which is reasonably suspected to be stolen property. Not only that, and who may reasonably be suspected of having committed an offence with reference to such thing that stolen property. Then, or who obstruct a police officer while in duty, while in execution of his duty. Here, police officer may arrest without warrant. Or who has escaped or attempts to escape from lawful custody, or who attempts to escape from lawful custody, then he may be arrested by the police officer without warrant and without order of the magistrate. Then, who is reasonably suspected of being a deserter from any of the armed forces of the Union. Reasonably. Always you have to mark the difference. Reasonable suspicion, then credible information, then here this reasonable complaint. So here, this is reasonable suspicion, suspected of being a deserter from any of the armed forces of the Union. Then, who has been concerned in or against whom a reasonable complaint has been made, or credible information has been received, or reasonable suspicion exists in this also of his having been concerned in any act committed at any place out of India, which if committed in India, that will be treated as, that will be treated as an offence, and for that offence he is liable to be, that is for extradition or otherwise liable to be apprehended or detained in custody in India. Then, being a released convict, if a person is a released convict, commits a breach of any rule made under subsection 5 of section 356. We'll discuss under section 356, a convict may be released on bond in certain cases. That is, then for whose arrest any requisition, whether written or oral, has been received from another police officer, provided that the requisition specifies the person to be arrested. Requisition has been made by one police officer to another police officer for arrest, and in the requisition the person arrested must be identified, properly can be identified, and offence or other causes for which the arrest is to be made. And it appears therefore that the person might lawfully be arrested without warrant by the officer who issued the requisition. Now, in a that means non-cognizable offence. That is non-cognizable offence, the police officer may arrest when that person refuses to give his proper name and address. He doesn't disclose his name and address as per section 32. That is subject to the provisions of section 42. No person concerned in a non-cognizable offence or against whom a complaint has been made or credible information has been received or reasonable suspicion exists of his having so concerned. So concerned means committing a non-cognizable offence shall be arrested except under a warrant or order of a magistrate. Now, section 41A onwards have been 41A, 41B, 41C, 41D. Those provisions have been that included in the criminal procedure code as per the what? That Basu case, DK Basu case. DK Basu, that is as per the DK Basu, some Supreme Court made some guidelines why that was to prevent that unnecessary arrest. That because while arresting a police officer, somebody's personal liberty is curtailed. So how that before telling somebody's personal liberty, some information should be given to the family members of the person who is arrested, and the person who is arrested by the police, he should know who is arresting him, which police officer is arresting him. Then that is, he must be allowed to consult a lawyer of his choice. All these requirements are there in because in DK Basu case. So that is section 41A says notice of appearance before police officer. 41A says that is also supplemented to section 41. The police officer shall, in all cases where the arrest of a person is not required under the provision of subsection 1 of section 41. In a case when arrest is not required, reason is to be required, notice is to be given. Issue a notice directing the person against whom a reasonable complaint has been made, credible information has been received, or reasonable suspicion exists that he has committed a cognizable offence to appear before him or at such other place as may be specified in the notice. Suppose the police officer is not satisfied that he's any of the condition as provided in section 41 of the criminal procedure code exists for the arrest of a person. So in such case, he is not to be arrested. So in such case, they are the police officer, but the police officer shall in all cases, he doesn't arrest a person who is against whom a complaint has been made, reasonable complaint has been made, credible information has been received, or reasonable suspicion exists that he has committed a cognizable offence, which is punishable with less than 7 years or up to 7 years, and the arrest is not required. So in such case, the police officer will give a notice to that person in all cases to appear before him or at such other place, either at the police station or such other place as may be specified in the notice. Where such a notice is issued to any person, it's the duty of that person to comply with the terms of the notice. When the police officer gives such a notice, as per section 41 notice, what is this called 41 notice? 41 notice, which case? Only cognizable offence, punishable with less than 7 years, and the police officer is satisfied, none of the conditions, none of the circumstances as provided in section 41 justifies the arrest of the person. So in such case, he will give, in all cases, the police officer will give a notice to that person, asking him to appear before him, or at the police station, or such other place. When such a notice is given to the person, to that person, it is his duty to appear before the police officer, as to comply with the police officer. Where such person complies and continues to comply with the notice, if that person appears or continues to comply with the notice, he shall not be arrested in respect of the offence referred to the notice, unless for reason to be recorded, the police officer is of opinion that he is ought to be arrested. If that person complies notice and is continuing to comply, he is appearing whenever required by the police before him, in such case he will not be arrested. But still a power is given to the police officer that if for reason to be recorded, the police officer is of opinion that he ought to be arrested, he can arrest. Now subsection 4, where such persons at any time fails to comply with the terms of the notice, suppose that person to whom a 41 notice has been given, he fails to comply with the terms of the notice, or is unable to identify himself, then the police officer identify himself, is not coming, and is not identified that I am that person, subject to such order as may have been passed by a competent court in this sphere, arrested for the offence mentioned in the notice. Now, section 41b says, what procedure is to be? You are aware of the fact, aware of the term arrest memo. Whenever a person is to be arrested, arrest memo is to be prepared. First requirement is that a police officer who arrests a person, he must wear the uniform, showing his name, displaying his name, and what is his rank. That first requirement. What? Every police officer while making an arrest, shall wear an accurate, visible, and clear identification of his name, which will facilitate easy identification. That means to prevent that in future, that means to ascertain the name of the police officer who arrested a particular person, such a provision. Because the accused should know that who is arresting, which police officer need the name of the police officer who is arresting. What it says? Every police officer, while making an arrest, shall wear an accurate, visible, and clear identification of his name. That is, in the uniform, that will be clearly, some badge will be there, which will bear his name, clear name for his identification, which will facilitate what for? So that he can be identified. Second, that is preparing an arrest memo. Then the second requirement is that the police officer shall prepare an arrest memo, that he prepare a memorandum arrest. We popularly, in general term, it is called arrest memo. Memorandum of arrest. What in the memorandum, master? Memorandum mentioning something. Memorandum of arrest. What will be the what are to be mentioned in the memorandum of arrest? That is memorandum of arrest. That is his arresting. Arrest memo is to be prepared. That arrest memo shall be attested at least by one witness who is a member of his of the person arrested. Arrest memo is to be attested at least by a witness, by a person, attested by one witness. That one witness will be the member of the family of the person arrested. Will let all respectable member of the society where the arrest is made. So either one of the members of the family of the person who is arrested, he will be taken as a witness to attest the arrest memo. Or if a respectable or any one respectable member of the locality will be taken as a witness to the arrest memo. Third is, that is to be countersigned by the person arrested. Countersigned means what? A signature. That means the person who is arrested, that is countersigned. He will sign in the arrest memo. Countersign. That one witness is taken of his family or any locality, a respectable person of the locality is taken as a witness to the arrest memo. And that will be countersigned by the person who is arrested. That is, in other words, by the accused. Then, fourth, this include the person arrested, unless the memorandum is attested by a member of his family. If a member of the family is attested the arrest memo, then this is not. Unless when member of the family is not attesting the arrest memo, then the police officer shall inform the accused that he has a right to have a relative or friend named by him to be informed of his arrest. Then if the family, one of the family member is not a witness to the member of arrest, then the police officer, if one respectable person of the locality is taken as a witness to the memorandum of arrest, in such case, the police officer will inform the accused that he has a choice to inform. He has a right to, not choice, he has a right to have informed the fact of his arrest, either to any of his relative, friend named by him, or to be informed of his arrest. Right to have a relative or friend. Which friend or which relative he wants that the fact of his arrest will be informed. Then if the accused informs, then that is to be complied. Now 41C says, control room at district. In every district, there will be a control room, from which the general public can know the persons who are arrested in a particular district, who have been arrested in a particular district. What it says, control room from a district. Control room at district. The state government shall establish a postal control room in every district and at state. A police control room will be established by the state government in every district, in district headquarters, and also in the state, in every state. The state government shall cause to be displayed on the notice board kept outside the control room of every district. The state government is a mandatory. The state government shall display what? On the notice board. Display on the notice board kept outside the control room. In the outside the control room, when a notice board is to be there, in that notice board, the state government shall display in the notice kept outside the control room of the every district, but the names and addresses of the persons arrested and the name and designation of the police officer who made the arrest. Not only the names and addresses of the person will be displayed in the notice board, but also the name of the police officer who has arrested that particular person that must be displayed in the notice. So, whether a person has been arrested or not, that can be known from the notice board, which is kept outside the what? Control room. That is control room. District police control room. In every district, there will be a control room. In the state, there will be a control room. This Subsection 41C supposed to provides the state government shall display the fact. What are the display the fact? The persons who have been arrested and the police officer who has arrested that particular person in the notice board, which is kept outside the control room. So that is there. Now, the control room are the police headquarters at the state. In every state, there will be a police head office, headquarters office, head office of the police in the state. The control room and the police headquarters at the state level shall collect from time to time details about the persons arrested. The state police control room, state headquarters, the police control room of the state headquarters will collect from time to time what? The information in detail about the persons arrested, nature of the offence with which they are charged, and maintain a database for the information of the general public. Database, because the public can know by true line that who has been arrested and for what offence is charged, and who arrested, nature of the offence with which they are charged, and maintain a database for this. Here, the name of the details about the person arrested, the name of the police officer who arrested, that is not to be maintained here, but that is two control rooms. One in district control room and the other is state control. In the district control room, police district control room, and there will be a notice board outside the control room displaying the name of the person who is arrested and the police officer who arrested. Then in the state government, state headquarters will collect what? Collect information from time to time about the names of the persons who have been arrested and for which offence they are charged, and that will be maintained in a database. Now, section 41D, a right of person to meet an advocate of his choice during interrogation. Such a right was not there in, though such a right is there in the Constitution, but such a right was not included in the Criminal Procedure Code. What it says, when any person is arrested and interrogated by the police, when a person is arrested or interrogated by the police, he shall be entitled to meet an advocate of his choice during the interrogation. Entitled to meet an advocate, that is, though not throughout the interrogation, but during interrogation, a right is given. Such a right, a police that means accused can take the help, can ask that his advocate will remain present. What it says, section 41D, when any person is arrested and interrogated by police, person is arrested and is interrogated by police, he shall be entitled to meet an advocate of his choice during interrogation. He has a right, and though not throughout the interrogation, that is allowed. So this is this amendment. This is all these 41A, 41B, 41C, 41D. Those are included in the Criminal Procedure Code in the year 2008. But 2008, that was those provisions were included by amendment. Now, section 42 is a very peculiar provision. Suppose a person against whom a non-cognizable offence, he commits in presence of a police officer, and the police officer asks that person to disclose his name and address, but he gives a fictitious name, or the police officer believes that he is not giving his correct name and address. In such case, he can be arrested. That is section 42. In one case, when in a non-cognizable offence, police officer can be arrested without warrant. In one case, that is, when in presence of a police officer, a person commits a non-cognizable offence and on demand by the police officer, that person doesn't give his correct name and address. In such case, the police officer can arrest that person and may also he may insist that person to give it. If he doesn't give his name and address, then he will be forwarded to the court. This is the provision say section 42. Arrest or refusal to give name and address when any person who in the presence of a police officer has committed or has been accused of committing non-culpable offence in presence of a person, police officer, any person commits a non-culpable offence and refuses on demand of such officer to give his name. It refuses in his police give his name and residence, or gives a name or residence which such officer has reason to believe to be false. Suppose it's a motor vehicle case. Somebody was going, that means without wearing helmet, the police officer, but he gives a fictitious name. So in this section, section 42, that person can be arrested. So when in presence of a police officer, any person commits a non-culpable offence and he, on demand of the police officer, being asked as being the required by the police officer, he doesn't give his name or address, or he gives his name which the police officer believes to be not correct or fictitious. Police officer has reason to believe false, he may that be arrested by such officer in order that his name or residence may be asked. In such way, the police officer may arrest that person only for limited purpose. What is that limited purpose? For obtaining his name and address, correct name and address. When the true name and residence of such person have been ascertained, suppose after arrest, the police officer could ascertain the true name and address of that person, then he shall be released on his executive. Then that means that person will be released on executive order with or without surety to appear before magistrate if so required. Provided that if such person is not resident in India, suppose that person is a foreigner, then the bond shall be secured by a surety or sureties resident in India. Now, should the true name and residence of such person not be ascertained, suppose in presence of a police officer, somebody commits a non-cognizable offence, and on demand by the police officer, he refuses to give his name and address, or he gives a name and address which the police officer believes to be false, then the police officer may arrest that person without order or without warrant of the magistrate, though because a non-culpable offence has been committed by that person. If that the correct address or name of that person would be ascertained, that he will be released on bond or either PR bond. If he is a foreigner, then sufficient security will be taken for his attendance. Suppose the name and that person, in spite of his arrest by the police officer, doesn't give his name and address, correct name and address, or the correct name and address of such person will not be ascertained by the police within 24 hours from the time of arrest, or should he fail to execute the bond, or when he has been asked to furnish a PR bond, he doesn't give it, or if so required to furnish sufficient surety. If he is outsider, he has been asked to furnish sufficient surety. If he doesn't give, then he shall forthwith be forwarded to the magistrate, nearest magistrate. Now 43A, arrest by private person and procedure on such. Section 43 gives power to a member of the public, a private person, to arrest a person, arrest any person, when in his presence a cognizable and non-bailable offence is committed. What it says, any private person may arrest or cause to be arrested, either he himself arrest or cause to be arrested any person who in his presence commits a non-cognizable, non-bailable and cognizable offence. When in presence of a private person, a person commits a cognizable and non-bailable offence, either he may arrest that person or he may cause that person to be arrested. So soon after arrest, if a police officer is available, he will produce before the police of that police officer. If police officer is not available, he will produce that person before the nearest police station. What it says, any private person may arrest or cause to be arrested any person who in his presence commits a non-bailable and cognizable offence or any proclaimed offender. Second is any proclaimed offender can be arrested by a private person and without unnecessary delay soon after arrest shall make over or cause to be made over. Either he himself will make over or cause is to be made over. Send that arrested person to any other person. So arrested to a police officer, not before the police station. Or in absence of a police officer, suppose a nearby police officer, nearby place, no police officer is available, then in such case, take such person or cause him to be taken in custody to the nearest police station. This is section 43. If there is reason to believe that such person comes under the provision of section 41, police officer can be arrested. That is, if before the police officer that private person produced that arrested person or produces that arrested person before the nearest police station. And if the police officer has reason to believe that such person is to be arrested as per section 41 of the CRPC, then he can arrest. If there is reason to believe that he has committed a non-coming offence, suppose the police officer, after arrest by a private person, the arrested person is produced before the police officer or before the officer in charge of the nearest police station, and that the police officer finds that he has reason to believe that he has committed a non-coming offence, and he refuses on the demand of police officer to give his name and residence. On demand of the police officer, he refuses to give his name and address, or gives a name or residence which such officer has reason to believe to be false. Or if that person gives his name and address which that police officer believes to be false, he shall be dealt with under the provision of section 42. As if that person had committed a non-coming offence in presence of the police officer, and on demand of his refusal to give his name and address, he will be arrested. And within 24 hours, if his name and address could not be ascertained, or if it is ascertained, then he will be released on bond. If it could not be ascertained, then he will be produced before the nearest magistrate. So in such case, in this manner, as per section 42, in what manner the arrested person is dealt, in that manner that is to be dealt. But if there is no sufficient reason to believe that he has committed any offence, suppose the police officer finds a private person has arrested a person, there is no sufficient reason to believe that he has committed an offence, then he shall be released at once. Now section 44, this gives a power to magistrate to arrest a person. Who is magistrate? Here not only judicial magistrate, but also executive magistrate. But when any offence is committed in the presence of magistrate, whether executive or judicial, when an offence is committed in presence of a magistrate, whether he is an executive magistrate or a judicial magistrate, again within his local jurisdiction, that offence must be committed within the local jurisdiction of the executive magistrate or judicial magistrate in his presence. He may himself arrest or order any person to arrest the offender. In such case, either the magistrate himself arrest or order the arrest of such person. No magistrate will never venture to make arrest personally and to attract the problems. So he may himself arrest, such a power is given, or may cause that person to be arrested, and may thereupon, subject to the provisions herein contained as to bail, as per the herein contained. Herein, as per the provisions of the CRPC, if he is entitled to bail, then he may be released or commit the offender to custody. Then any magistrate, whether executive or judicial, may at any time arrest or direct the arrest in his presence within his local jurisdiction of any person for whose arrest he is competent at the time and in the circumstances to issue. This subsection 2 says that any magistrate or executive may at any time arrest, himself arrest or direct any person to be arrested against whom he is competent, any person for whose arrest he is competent at the time and in the circumstances to issue one. That means who has armed bail, etc., competent to arrest him, or in the circumstance to issue a warrant. Now section 45, protection of members of the armed forces from arrest. Suppose an armed force officer, he commits certain offence while discharging his duties, then for his arrest some restriction is there. notwithstanding anything contained in section 41 to 40. 41 when police officer about to arrest, 42, 42 what? That is, if a person commits a non-cognizable offence in presence of the police officer and he refuses to furnish his name. Section 45 gives, notwithstanding anything contained in section 41 to 44, no member of the armed forces of the Union shall be arrested for anything done, it is very important, or purport to be done by him in the discharge of his official duties, except obtaining the consent of the central government. This is very important. Suppose a police, suppose a armed force officer is discharging what? Containing under shall be arrested for anything done or purport done him in discharging of his official. Discharging of official duty is something is very difficult to understand. Sometimes when an armed force officer, while in one case he is moving in a train and on duty, he is going from one place to another. In the train he commits an offence. For that, further section 45 will be applicable. So for discharging duty is something different. In some cases, the permission of the central government is required. But in private capacity, and armed force officer, suppose he is on leave, he commits certain offence in his house, in his village. For that, section 45. But while on duty, sometimes a armed force officer is to be treated as duty while on movement from one place to another. For anything done, while discharging duty, then for that for his arrest, the consent of the central government is required. The state government may by notification direct that the provision of subsection 1. The state government may also direct by notification that the provisions that no any other force, when a force who is on duty, if he commits any offence, he cannot be arrested without the consent of the central government, state government. So that's why the state government may by notification direct that the provisions of subsection 1 shall apply to such class or category of the members of the forces charged. Some category or the class of forces charged with the maintenance of public order as may be specified in the notification. If the state government will notify certain categories of armed forces who are charged, or a that means certain category of officers will not be arrested without the consent of the state government, then that will be done. That can be done wherever they may be serving, and thereupon the provisions of the subsection 1 subsection shall apply as if for the expression central government occurring therein in subsection 1 as state government were substituted. Now arrest how a person is to be arrested. While arresting a person, whether the police officer can touch the body of the person, whether the police officer can take that person into custody physically. Such a provision, is there. You can find the answer in section 46. What it says? In making an arrest, the police officer or other person making the same, either a private person, in whose presence a cognizable or non-cognizable offence is committed, he can arrest. So, in making an arrest by police officer or other person making the same, shall actually touch or confine the body of the person to be arrested, unless there will be a submission to the custody by word or action. That means, if the person who is to be arrested, he submits to the police custody, either by his word or his action, then in such case, his body cannot be touched. Body or person making the shall not actually touch or confine. So now, section 46 says, when the body of an arrested person will be touched or confined. If the person who is to be arrested, he submits him to the custody of the police, either by words or his action. Suppose police says, I want to arrest you. Yes, that person says, yes, I am going with you. Or he goes with the police. Then that amounts to submission of that person to the police custody. So in such case, the police has no power to touch the body or of the person arrested or to confine the person. Section 46 says, arrest is to be made by touching the body of the person who is to be arrested or confining the person who is to be arrested. But unless if that person submits him to the police custody, either by words or by action, in such case, actual touching of his body or confining the body of that person who is to be arrested is not required, will not be made, provided that, suppose a woman is to be arrested. In such case, provided that where a woman is to be arrested, only the circumstance indicates to the contrary. If the circumstance indicates doesn't contrary, her submission to custody on an oral intimation. If the woman simply orally intimates, yes, I am submitting myself, that will be sufficient. Intimation of arrest shall be presumed. Her submission to custody on an oral intimation of arrest shall be presumed, and unless the circumstance otherwise requires, or unless the police officer is a female, the police officer shall not touch the person of the woman of making her arrest. The male police officer has no right, cannot touch the body of the woman accused. What it says? When a woman is to be arrested, mere saying of that woman that she is submitting herself to the custody of the police is sufficient. That he has submitted. He has submitted his or to the police custody. And in such, unless the circumstance otherwise requires, or only the police officer, or if the circumstance otherwise requires and the police officer is a woman, then only woman police officer can touch the body of the female accused or female person who is to be arrested. So this is, if such person forcibly resists the endeavor to arrest him, suppose that person forcibly resists and the endeavor, the attempt to arrest him, or attempts to evade the arrest, or the attempt to evade the arrest, such police officer or other person may use all means necessary to effect the arrest. You are aware that police is the force of the state. Through police, the state compels a person to obey law, takes a person into custody. So if such person forcibly, if any person who forcibly resists the police officer in his endeavor to arrest him, in our attempts to evade his arrest, such police officer or other person may use all means necessary to effect the arrest. Nothing in this section gives a right to cause the death of a person who is not accused of an offence, punishable with death or with imprisonment for life. This section, subsection 3, gives power to make encounter, police encounter, killing a person. What it says? When a person resists the endeavor of the police to arrest or attempts to evade his arrest, suppose a person is arrested, then he just escaped from police custody, thereby he evades the arrest. So in such case, the police has been given power to use all means necessary to effect the arrest. Subsection 3 says, nothing in this section gives a right to cause the death of a person who is not accused of an offence punishable with the death or with imprisonment for life. In other words, the police has a right to cause death of a person who evades arrest, who attempts to evade arrest, if he is liable for the offence, if he is accused of an offence, punishable with death or imprisonment for life. So this subsection 3, by applying this subsection 3, sometimes police encounter takes place. Because when the accused, when he escapes from police custody and is accused of committing an offence, punishable with death or imprisonment for life, and for his arrest, police can make all endeavor to arrest him, to prevent, that means resist the endeavor to arrest him or attempt to arrest him. Such police officer or other person may use all means necessary to effect the arrest. So in such case, the police can also cause death of that person. Subsection 4, save in exceptional circumstances, no man shall be arrested after sunset. This is, no man shall be arrested after sunset and before sunrise. and where such exceptions only in exceptional circumstances. Say that only in exceptional circumstances a woman can be arrested before after sunset before sunrise. Otherwise, he cannot be arrested. And before sunrise, and where such exceptional circumstances exist, the woman police officer shall, by making a written order, only a woman police officer with a report obtain the prior permission of the judicial magistrate of the first class, within whose local jurisdiction the offence is committed or the arrest is. That means a woman accused can be arrested, cannot be arrested after sunset before sunrise. But in exceptional circumstances, if the circumstances so require, suppose he is a hardcore criminal or a Maoist or etc., in such case of arrest is required, then a woman police officer on giving report and obtaining permission from the judicial magistrate under whose jurisdiction such arrest will be made or whose jurisdiction offence has been committed, can arrest that woman officer after sunset before sunrise. We have completed so far. In the next class, we will go for shorts. Thank you all.